We are live on YouTube and now we are recording.
Okay, I will call to order the Monday, January 11th, 2021 joint meeting of the Oregon City Historic Review Board and the Planning Commission. And this is for purpose of legal training. We'll start, I'll start and then I'll call on each person. If you could just give us your name and your neighborhood association and how long you've been on the board. My name is Mike Mitchell. I live in the Caulfield neighborhood, and I have been on the Planning Commission for 2 years. Let's start with the Historic Review Board. Grant Blythe, is he on? I don't see him. Okay. How about Ray Stobie?
Hey, Mike. Yeah, Ray Stobie, over in Hillendale, and I'm representing the Chamber of Commerce on HRB and going into my 3rd year, I think.
Terrific. All right, thank you. Carrie Crook. Hi, Carrie.
Hey, everyone. I'm Carrie Crook. I'm with the McLaughlin Neighborhood Association, and this is my first time on the board. Just happy to participate.
Terrific, thank you. Paul Edgar.
Hi, I'm Paul Edgar out of Kanema area. I'm a newbie to the HRB, but I've had numerous opinions over a lot of years.
Okay. Sabrina Ferry.
Hi, I live in the McLaughlin neighborhood, so I would be with the McLaughlin Neighborhood Association, and I am brand new to the board.
Great. And I see Grant Blythe has joined us.
Yeah, Grant Blythe. This will be my 5th year on HRB.
Great. And just for my curiosity, which one of the HRB members is the architect representative?
That would be me, Sabrina Ferry.
Okay, thank you. All right, we'll move on to the planning commissioners. Dirk Schlagenhofer.
Dirk Schlagenhofer, I'm in the Gaffney Lane area, and this is my 3rd year on the Planning Commission.
Greg Stoll. You're muted, Greg. Not hearing you. Okay, we'll come back to Greg in a second. Patty Gage.
Hi, Patty Gage, and I've been on the commission for, this is the beginning of my 3rd year, and I live in the Central Point neighborhood.
Okay, Greg, I think I heard you. Why don't you go ahead and try again?
Cool. Yeah, Greg Stoll. I live in the McLaughlin neighborhood, and I'm starting my 3rd year on the Planning Commission.
Great. And Chris Staggs.
I think I missed what I'm supposed to talk about here. What's the protocol?
Just your name and the neighborhood association you live in and how long you've been on the Planning Commission.
Okay. Name is Chris Staggs. I'm an architect and locally developing property. Okay. I live out off of South Leland Road, which is an area where the neighborhood association is inactive at the moment. And I've been on the Planning Commission now for about a year.
Okay, and our 2 new members of the Planning Commission, Lisa Novak.
Hey everyone, I'm Lisa Novak. Live in the Park Place neighborhood, and this is my 1st year on the Planning Commission. Great to be here.
Welcome, nice to have you. And Daphne West.
Hi everyone. I've lived in the McLaughlin neighborhood for 34 years. My first night on Planning Commission, I think I was on maybe in 2005 for about 6 months. And it's going to take a little refresher course here.
All right, thank you very much. I think that's everybody. I see we have 1 member of the public on, but I think that's all of our boards and commissioners. So move on to legal training, and Ms. Turway, we'll go over to you.
Great. I'm happy to introduce Carrie Richter, who is our Assistant City Attorney.
Well, hi, everyone. Welcome. Can you hear me?
Yes.
Yes.
I launched into a 45-minute diatribe and everyone says, you're on mute. So I'm going to share my screen because slides are going to be more interesting than looking at my dumb face. So let's do that. And so I hope everyone can see these slides. I know that I've got some people who have been on the Planning Commission or HRB for many years, and some of you who are brand new to planning generally. So I am going to try to run the gamut here and give you all something new that you maybe didn't know, or if you did know, you are remembering it again. And so that everybody gets something out of this. Since we are all virtual, unfortunately, I am going to try to ask you to hold off on comments until the end. But if you have something burning and it's, the time is right, please feel free to interrupt me. We only have an hour, and you can always count a lawyer to smush 4 hours worth of stuff into 1 hour and just talk really fast, which isn't too helpful. But I'll try to take a breath on occasion and allow folks an opportunity to interject when I think of it. But again, I'm going to try to leave some time at the end for folks to ask questions, comments. We are not going to talk about any applications that are pending before either body. And I would urge you not to talk about any of those things because we're just talking about training here, and save those questions related to active applications for the public hearing when those are discussed. So one of the things that I want to start with, and I know Laura circulated some materials, a whole bunch of materials, in fact. One of the materials is an American Planning Association Planning Commissioner Manual, and it starts with sort of the background roots of land use planning and what land use planning should do. And I think it's important when we sort of start out thinking about our roles as decision makers to think about these sort of background principles as giving the roots to what it is we are charged with accomplishing. And land use planning at its base, at its core, as set forth in Goal 1, is to provide citizens an opportunity to play a meaningful role in the development and implementation of plans and regulations. And so the Historic Review Board and the Planning Commission play a pivotal role in providing that forum and providing a place where the public feels comfortable voicing their opinions and knows that the Planning Commission and Historic Review Board will listen to those comments and be responsive. And so that's the procedural role that that these bodies play. The second point is that we have an obligation to protect for the health, safety, and welfare of the citizens. And that's where all the regulations, all the land use planning policies come from, right? This effort to further the health, safety, and welfare of citizens, business owners, and of Oregon City. So that includes conservation of natural resources, protection of historic resources, and to maximize community strengths. And that's what all of our regulations are intended to further. And so when we, you all are going to be pivotal in participating in the adoption of the new comprehensive plan. And this is sort of the base substantive standard that we're looking for when we talk about what plan policies should change and in what ways in order to maximize community strengths. The third bullet point relates to efficiency in the use of land and public facilities. So you are going to be having an opportunity to weigh in on water line capacity, transportation infrastructure, adequacy, all those kinds of public facilities issues. So planning broaches that issue as well. We want to assure equity and strive to expand choice and opportunity for all persons, especially disadvantaged groups and individuals. And this is a really critical one, and one that I know the planning office takes seriously, and I do too, and I know you all will too, both in terms of participation in meetings. And Zoom, I think, may go a long way to helping encourage participation in meetings in an effort to encourage equity and expand opportunities. Pay special attention to the interrelatedness of decisions and the long-term consequences of present actions. So land use planning sort of touches on everything, right? We're looking out 20 years, 30 years in some circumstances when we're making a decision based on today. And so we need to be thinking about the interrelationship of the future to the present, as well as the interrelated nature of our decisions. We want our decision-making to be coherent and make sense when we look across a horizon. We don't want the setbacks on one building to only be 5 feet, and then next building be 35 feet, and then the next building be 5 feet again. We want some coherency between decision-making. And so we want to be thinking about sort of how are we treating applicants the same? And that is another important part of planning. And we need to keep in mind our community goals, priorities, and also the budget constraints. We can't be everything to everybody. And so there are limitations to what the city can and can't do, and we need to keep that in mind. So everybody in a land use planning procedure, regardless of the procedure, plays a part, right? Everybody has a different job to do. And it's important that we understand the different responsibilities that come with review, whether or not we're considering something big like adopting a new comprehensive plan, or if we're just reviewing an application for a proposal to a specific property, something very narrow and very specific. These roles and responsibilities sort of apply to all the different types of decisions that the Planning Commission and the HRB will make. First, the planning and legal staff, their job is to administer the land use process. So city staff issues the notices that go out. They're responsible for drafting the staff report, and they're responsible for advising and helping the Planning Commission and HRB in making decisions. They are charged with knowing what the regulations are and helping to inform the HRB and the Planning Commission in their review. They are also charged with assisting the public. So they have had a lot more conversations with applicants than the decision makers have. And they have had more conversations with neighborhood groups than the decision makers have. And so they are to be a resource to the Planning Commission and HRB in evaluating applications that come before you. The Planning Commission and HRB's role is to, first of all, reflect community values in the planning policies that get made. So this bullet relates to legislative decision-making, the kind of decision-making where you all are making policy. Adopting a new comprehensive plan is going to be making policy for the city. So that is, your job is to help sift through and hear testimony and put forward policies that reflect various community values. And what I heard in your introductions were that you are all from different parts of the city, and so you all have different understanding and experience with respect to those community values, and all of that input is going to be invaluable moving forward. The second bullet point relates to what we call quasi-judicial decision-making. This is a different kind of decision. This kind of decision is where you will be asked to evaluate whether or not certain approval criteria are satisfied with respect to a specific application, an application to develop something on a piece of property. So this is where instead of making policy, you are interpreting and applying the policy to a particular application. And so your job is to make those interpretations and apply those regulations and come to a decision. Your job is also to educate the public and provide, sorry, I have a motion sensor on my office lights. Your job is to educate the public and provide a public forum for the hearing. We talked a little bit about that. Your job also is to do homework. And, you know, a lot of you may say, I didn't sign up for homework, but there is a lot to read as a planning commissioner and HRB member. You are going to get applications that are lengthy. You are going to get staff reports that are lengthy, and it can be daunting. And your effectiveness as a commissioner will largely be based on how much homework you do and your efforts at the outset to understand areas that you're confused about before you come into the hearing. Have a conversation with staff about things you don't understand about a particular proposal, criteria that are confusing to you. That effort will pay dividends by you being able to run an efficient meeting, being able to ask coherent questions, and being able to participate in a way that is helpful to the process. Your job is to treat staff and elected officials with professionalism and respect. And be courageous. Don't avoid hard decisions. You were selected in this job because the decisions are hard. If it was easy, we wouldn't need a planning commission and a historic review board. We need you to grapple with the difficult questions. When planning staff works with the attorneys to draft code, we can't imagine all the scenarios that these criteria will come up with later. And as much as I wish I could identify all the ambiguities at the outset, there will be things that will require interpretation and will require discretion. And so you have to have the courage to speak up, and sometimes you will disagree with your fellow commissioners, and that disagreement can happen with professionalism and courtesy, but you can't be afraid to disagree. And so those are some of the responsibilities for the planning commissioners and HRB members. The applicant plays a really critical role in these processes when it comes to these quasi-judicial applications. It is the applicant's job to come to the city with an application that shows that the applicable approval criteria can be met. So it is not the city staff's obligation to go out and do some sightline drawings of what a building will look like. This is the applicant's job. It is the applicant's job to show you that the proposed windows are compatible or they meet the transparency standards. These are all the applicant's job. And we often say the applicant bears the burden of proof. That means the applicant has to come to the proceeding with evidence to show that the standards can be met. And so you are going to find as a review body that applicants come with different levels of experience, different levels of understanding, different levels of support in these efforts. And it is our job as a hearings body to help educate these applicants and encourage them to meet their burden of proof. And I know that the planning staff has to do that a lot, but you have to help support planning staff in that effort by encouraging and educating these applicants about what it will take for them to meet their burden of proof, and not to either not worry about it or foist that obligation on either opponents or city staff, when that burden always, throughout our reviews, always rests with the applicant. So this applicant also has to respond to arguments that are raised during the hearing. And that goes to this idea of bearing the burden of proof. Neighborhood groups and other participants in a land use review, their job is to participate, right? We want to encourage them to participate. We want to provide the forum for them to participate, either orally or in writing. And their obligation is to raise concerns that are directed at the applicable approval criteria. And this is really important because we often see participants in a land use hearing come in and tell decision makers things that have nothing to do with the applicable approval criteria. The example I always use is when a church comes in, files an application to expand or change their parking lot or do something, we often get testimony from people in support of the church saying the church does great work and the church's mission is really fantastic. And that may be true, but that is not directly related to the applicable approval criteria. And your job as decision makers, when you're reviewing an application to develop land on a single parcel or a small parcel, a few lots, your job is to sit as the judge. And the judge can only evaluate applications against the approval criteria that have been adopted. So if how often an airplane flies over a property is not one of the applicable approval criteria, many flyovers would not be a basis to approve or deny an application. So all the testimony that is presented at a hearing needs to relate to the applicable approval criteria, because that is the thing that you are charged with evaluating. So we want to encourage people, educate the public about focusing their testimony on those criteria. The planning staff in Oregon City, and I think it's recommended for Planning Commission and HRB members to comply with the APA Code of Ethics and Professional Conduct. And this is a corollary to the ethics rules that apply to municipal officials. And I think Laura circulated those materials. But the APA Code of Ethics and Professional Conduct is relevant too, because I think it helps you understand what the planning staff is subject to, and it applies to these rules apply generally to lawyers too, but that ought to sort of guide the Planning Commission as they hear applications. And the overall responsibility is to the public, always being conscious of the rights of others by expanding opportunity, providing clear and accurate information to affected persons and decision makers. And all of us, I know, are trying our very best to do just that. Be diligent, creative, and competent in the performance of the work we do. Contribute to the knowledge and techniques that respond to the community problems in a fair and professional manner. Not engage in activities that create a conflict of interest or engage in private communications with participants. There's a typo there. If the discussions relate to a matter over which we have authority to make a decision. And we'll talk a little bit more about conflicts of interest and ex parte contacts with respect to your review in a little bit. And not deliberately misrepresent the qualifications, views, and findings of other professionals. And you know that when an application comes before you, the city staff is going to have put together a staff report, which is sort of staff's identification of the applicable approval criteria and their evaluation of those criteria based on the evidence that has been submitted into the record. And sometimes, like I said, that application includes professional reports from traffic engineers or geotechnical engineers, and planning staff evaluates that based on the expertise of those particular professionals. And it is your job then to look at that evidence and decide what weight to give it. But that is what staff does, consistent with this code of ethics, by doing the very best it can to correctly represent the qualification, views, and findings of these other professionals. And when you think about it, the success of the planning program relies on professionals to act with integrity. And I know that Laura works really hard to have her staff do just that. And so we want to be open and acknowledge that effort in a way that is respectful. So I talked a little bit about types of land use decisions, and I know that I've used this slide before, so I'm not going to spend too much time, but there are different kinds of decisions that Oregon City makes on the planning side. The type of decision is determined by how discretionary the criteria is that has to be applied, and whether or not the decision maker is, like I said, making policy or applying policy. So are you acting as a political body making policy, or are you evaluating a proposal sitting as a judge? So type 1 decisions are decisions that are made by staff. These are decisions that are what we call clear and objective, and they don't require the exercise of discretion. And so these decisions do not come before you. These are building permit decisions are the most obvious example, where the planning staff evaluates a proposal to see if the setbacks are 5 feet, like the code says, whether the building is 35 feet tall, like the code says, and then the sign off for a building permit. There is no notice, there's no hearing, there's no appeal. There are 3 types of quasi-judicial decisions, and they all they go up in Roman numeral based on how much discretion is exercised with the decision. Type 2 decisions are limited discretion decision making. These are primarily site plan design review decisions, and these are not decisions the Planning Commission or HRB will see. These decisions include notice to neighbors, an opportunity for neighbors to submit comment, decision by the planning director, and then an appeal right directly to the city commission. Where you all are going to see the action is in type 3, type 4, and legislative decisions. These are the most discretionary decisions, and these are decisions where the city has determined that because these are discretionary, they require a public hearing, public notice, public hearing, and a right to appeal. And that public hearing is before HRB or the Planning Commission. That's the first step for these applications. Type 3 decisions are the decisions where you're sitting as a judge. Here you are evaluating an application to determine whether or not it complies with the applicable approval criteria. These decisions, once made, carry with them appeal rights to the city commission. And what's important to know about the appeal right to the city commission is that the appeal hearing is what we call on the record, meaning that the applicant and opponents or the public's only opportunities to submit evidence is before you. So you are the fact finder, the only fact finder in these types of cases. So it is critical that you understand and question the participants to get a good handle on what the evidence is, so that the record is made in a complete way before the decision is made. Type 4 decisions are plan amendments and zoning map amendments. So that's where a applicant wishes to do something that the zoning doesn't currently allow. So they need to amend the zoning or the zoning map or the comprehensive plan map to allow them to do the thing they want to do. So if you're in a residential zone and you want to do something, a commercial use or an industrial use that the zoning does not allow, you would need a plan amendment and zoning map amendment in order to do what you would like to do. And so that is sort of a surgical change to the whole overlay of zoning in the city. And those are what we call type 4 decisions. In these kinds of decisions, the planning commission and HRB would be the first stop. And then they make a recommendation to the city commission from there. I don't think, correct me if I'm wrong, Laura, but plan amendments, zoning map amendments don't go to HRB, right?
Correct.
So this would just be in planning commission's area. Okay, and then legislative decisions. This is to be contrasted with the quasi-judicial decisions. Legislative decisions are these policy-making decisions that include amendments to the plan and zoning code, text or map, and these are big areas. So these are annexation decisions that are large scale. These are master plan amendments that affect large areas of the city. So these are where you are making policy, and the things like adoption of a new comprehensive plan is going to have hearings before the planning commission. I'm assuming there'll be some discussion before the HRB with respect to historic resources overlay. And then there will be a recommendation from both bodies to the city commission about what to adopt when we get to that point. Legislative decisions are, like I said, political decisions. So the expectation is that there will be lots of discussion, a robust discussion between the public and decision makers about an application or about a proposal as it's put forth by staff. And the review is what we call de novo, meaning that the record is open and it's sort of much more free and flexible. So quasi-judicial hearings, going back to the more narrow application evaluation by you as a judge. Every hearing to evaluate one such proposal will come with a series of disclosures. And your chair will read these disclosures at the beginning of every meeting. They are required to be read by statute, not because the city attorneys stick in the mud and trying to put everyone to sleep before the hearing even starts. But the hearing requirements that the chair will read, I want to sort of give you the highlights so you can you will understand what they say, so you can tune it out when the chair reads it in the future. But they're really critical and they're important because they tell the public what their rights are, assuming that the public has never been to a public hearing before. And so what they say is that individuals have an opportunity to be heard. They have an opportunity to present and they have an opportunity to rebut evidence. They have a right to an impartial tribunal. That means a tribunal that is free of bias. They make it clear that there's a staff report and that staff report is available 7 days in advance. And I believe that the planning department's practice will be to email these staff reports to you as soon as they're available. You have an obligation through the land use review process to raise all of the issues in order to preserve those arguments on appeal. Once the planning commission and the historic review board make a decision, I mentioned that decision is appealable to the city commission. The city commission will make a decision, and the city commission's decision is then appealable to the state land use board of appeals. That is the appellate court charged with reviewing appeals throughout the state of Oregon. One of the rules at LUBA is that items have to have been raised before the local government in order to be raised at LUBA. So there is this obligation on the part of all parties to raise issues. And if you don't raise them, that these issues, the arguments, your challenges, then you are waived. Your arguments are waived at LUBA. So you speak now or you forever hold your peace, as it were, at the Planning Commission and the Historic Review Board. And it's important that you understand that so that you can help the public articulate their position. If you don't understand their position, you ask questions in order to understand, to better understand their position. And the more transparent the effort, and open the communication is, the better. The failure to raise constitutional issues precludes enactions for damages in circuit court. That's another waiver issue. And then finally, on this point of right to an impartial tribunal, I want to talk a little bit about the component parts of an impartial tribunal. First, you have to be free of actual bias. And bias means a predisposition towards a particular position, making it impossible to make a decision based on the criteria and the evidence presented. So you may feel very strongly in favor of veterinary clinics and that there need to be more of them and there aren't enough of them, and that you cannot evaluate a proposal for a veterinary clinic or anything that has to do with a veterinary clinic because you feel so strongly that there aren't enough veterinary clinics, and whatever those applicants want, the city needs to provide those. In those cases, you have actual bias. In other words, you cannot make a decision based on the approval criteria and the information presented because you have a such a strong personal connection towards a position that you cannot set that aside for an application. And but don't interpret what I'm saying to mean that you are not allowed to have feelings about things happening in the city. You were selected for this job because you care about the city and you want to make it a better place. And of course you have strong feelings about things that happen in the city. Of course it is not expected that you all live under a rock and you have no idea what the traffic on Beaver Creek Road looks like at 5 p.m. The question is, can you put your personal feelings about that traffic or your personal perspective about that traffic aside and evaluate the proposal based only on the materials in the application, the materials that have been submitted as part of the record? If you cannot, and I could go on for hours about all the things I probably could not put in a box and not take into account if I were sitting in your shoes. So it is nothing to be ashamed of or embarrassed about if you cannot put your personal feelings aside and make a decision based on the application. That's why there's so many of you. We've got spares, right? So if you feel like this application is too close to where you live, or your name or someone you care about lives, or it's an application that this particular applicant, either the person or the proposal, is just something that is fundamentally, you cannot set it aside. You need to let me or Lauren know that you have some concerns about, excuse me, about bias, and that you would rather not participate in that decision. And we will make accommodations. So the point about bias is, in cases where you cannot make a decision based on the criteria, then you need to sit out. But if you can make a decision, we welcome you to participate, because we know that you all care strongly about Oregon City and you understand your role as a judge in these types of decisions. The second type of component part of having an impartial tribunal is that you have to be free of conflict of interest. So you can't have any direct pecuniary benefit to a decision maker or family member. And the key component, legal component of this language is the word direct. So if my son mows the grass at the McDonald's, and the McDonald's is filing an application to expand its footprint, and my son either will lose his job because expanding the footprint will take up the area that he mows the grass, or because McDonald's will make so much money that they'll pay my son more to mow the grass, I have a direct pecuniary interest. Okay? That should be distinguished from a circumstance where I am an architect who designs buildings, so I make a living by development generally occurring. There is no direct pecuniary interest if an applicant files an application to build something new, when I am not the architect on the project, neither is the company that I work for the architect on the project. So again, if you have, there's a lot of nuances to all of these things. So if this comes up for you, you'll want to talk to Laura and perhaps me about sort of the circumstance, but you need to be aware that that's what a conflict of interest means. The third part of an impartial tribunal is to have a decision made that is free of ex parte contacts. Ex parte contacts are discussions that happen outside of the public hearing forum. So this is a circumstance where you're in the grocery store and somebody comes up to you and says, Commissioner Novak, you are going to be reviewing an application for X, and I have concerns about that. Or I think it's a wonderful idea, you should vote for it. And this is the invitation that you know that somebody wants to talk to you about an application that is before you. And there are a couple of things you need to know about. These are called ex parte contacts, right? And the reason why we don't want those contacts to happen is because nobody else, none of the other commissioners or any participants in the hearing know about that conversation. They don't get a chance to question any party about that conversation. So the law acknowledges that those conversations are going to happen. There is, again, you have to be living under a rock to think that people aren't going to know that you're on one of the boards and that they see an audience, right? They see an opportunity to talk to you about why the parking is not enough, or why the street lights aren't in the right location, or the tree removal is too great. And they're going to take that opportunity. And you have two choices when somebody invites that kind of conversation. You can say, I appreciate that you have concerns and I urge you to come to the hearing on Monday where we're going to talk about it, and you can make those comments, those concerns heard. That's one option. The second option is to have a conversation with them about that, whatever it is, but you need to disclose that conversation at the public hearing where the topic is discussed. So you will need to say, I ran into Jerry Smith at the grocery store and he wanted to talk to me about tree removal. And he told me about how the removal of this particular tree in this location is a real problem. And I told him that I would forward that concern to the Planning Commission. So then you have put the communication on the record so that the applicant, opponents, everybody has an opportunity to weigh in on what Mr. Smith told Commissioner Novak about the tree removal. This same ex parte contact obligation applies when you read something in the newspaper about an application. You read a blog post about an application or a proposal. All of those things are ex parte contacts. They're evidence you're getting that relate to an application, that you're getting it outside the public hearing. And the best practice is to err on the side of sharing too much and just forward the blog post that you read onto planning staff, and they will make sure that that newspaper article or that blog post or whatever it is that you have access to gets into the record where everyone will have an opportunity to respond. So moving beyond the procedural component parts of a decision, land use applications or decisions have to be based on the approval criteria. And this is going to require you to, one, identify the approval criteria and apply it. And these approval criteria by their nature are discretionary. That means they're subjective. That means they require the exercise of judgment. And that is what you are charged with doing, is exercising that judgment. And so you have to interpret what a criterion means. And for example, I just picked one out of the code for site plan and design review. One of the criterion is that pathways, pedestrian pathways between the street and buildings fronting on the street shall be direct and not cross a drive aisle. So what does it mean to be direct? Your job is to interpret what it means to be direct. And in order to do that, you have to look at the language of the criterion. You have to look at that's called the text. You have to look at the context. You have to look at the other language around the term direct in that example. And you have to look at the policy that furthers the provision. So for example, there are exceptions to the direct obligation for pedestrian pathways, and that has to do with typography and natural resources. Doesn't say historic resources. I would think that you could interpret that exception to include historic resources, even though the language talks about natural resources. So that's the type of discretion, and that's the type of contextual support you might find from other language. You might look to the policy of encouraging pedestrian access and providing opportunities for pedestrians to move safely between buildings as a basis to interpret what it means to be direct. So all of this kind of interpretive discretion runs to you, but it has to be within the text, context, and the policy for the provision. With respect to the evidence, you've got an obligation to identify what facts in the record lead you to a conclusion that a criterion is satisfied or not. So, and that evidence needs to be in the materials in the record. Your personal knowledge is not evidence in the record. So if you are a person who has worked with on riparian corridor water quality protection issues in your in your professional life or just as an interest, as a hobby, that personal knowledge about water quality cannot be the basis for your decision unless you disclose that knowledge and whatever facts are helping you to make a decision in advance. So this personal knowledge component is very much like the ex parte contacts point. What we don't want to have happen is we go through the public hearing process, we hear from the applicant, we hear from the public, there's questions, there's opportunity for rebuttal, and then you're deliberating. And I say, well, you know, I am a trained wildlife preservationist, and I happen to know that squirrels particularly love this kind of tree. So I am not going to vote to approve an application that results in the destruction of this kind of tree. And if I share with the commission or a historic review board that information after the record's closed and during deliberation, no party has had an opportunity to question me about my knowledge about that animal, that tree, all the facts surrounding my perspective on the preservation of that tree. And that compromises the integrity of the process. And that's a problem because we want the decision to be based on evidence that's in the record. So your personal knowledge is not evidence. And if that personal knowledge is critical, you need to make that information known while the public record is open. That means the time for folks to testify about that personal knowledge is available. But the best practice here really is not to allow your personal knowledge to color your evaluation of the application against the criteria. The other thing to note about evidence is that if an applicant shows that the criteria are satisfied, the application has to be approved. We can't deny an application based on facts that are not in the record. So everything has to have evidentiary support, whether it's approval or denial. And that is something that it takes time to understand the evidence. It takes time to question participants about the evidence to make sure we fully understand it and that we make a decision based solely on that evidence that's in the record. Where there is conflicting evidence, so let's say we have a transportation engineer's perspective, the city's transportation engineer has submitted some evidence evaluating a transportation analysis, and we have residents who may have hired their own traffic engineer to evaluate traffic. So we have this situation where we have conflicting evidence. It is Planning Commission and Historic Review Board's job to evaluate the quality and character of that evidence and to decide which evidence is more reliable and entitled to greater weight. So that is part of your job as well. Finally, if the review body decides that conditions of approval are necessary, let's say that the application does not show that certain criteria are met, but conditions of approval can ensure that that the criteria are satisfied. It is up to the HRB and the Planning Commission to assist in the drafting of those criteria, of those conditions, and doing everything we can to make those conditions as clear and objective as we can, free of discretion as we can. And that's a tall order and it takes time, but I know that we can do it, but we have to take the time to identify what we want the outcome from the condition of approval to be, and then come up with language that's as non-discretionary as possible. The city has limitations to what it can demand of applicants. The limitation is set forth in the Fifth Amendment, takings clause, and those limitations are what we call rough proportionality. The city cannot demand more of an applicant in terms of dedication of land as part of an application, or street improvements, or sidewalks, or all kinds of public amenities that come as part of an application. The city cannot demand more of those applicants than is roughly proportional to the impacts of those development, which is a lot of legal language to say that we cannot force an applicant to build a 4-lane freeway when they are trying to build a house, right? The traffic they will put on the street from that house does not require a 4-lane freeway. And so we cannot force them to do that. We cannot ask an applicant to build a large public park as part of an application for a small shopping center. We have limitations on what we can ask an applicant to do in order to approve an application. And so that sometimes comes up in the context of road improvements. We would like to encourage applicants to provide as much infrastructure as we think that an application needs, but we can't require too much. So we have to balance those interests consistent with the Fifth Amendment.
Carrie, I'm just gonna, Carrie, real quick, just time check this, 3 minutes.
Yes, I know, and I'm gonna be done in 5. Can I have 5? Okay, public records, really quick. So public records requirements. As public officials, all of your discussions of public business are public records, and that means they are discoverable, either in the face of a public records request or in the course of litigation. And so, and that does not matter if you email somebody about on a personal email, using a personal email address. If you're talking about city business, those things are public records and they are discoverable. So if the city hasn't already, I think they will be issuing you an email address with a city email address, and I encourage you to conduct all city business on using that email address. The important distinction is that it's city business. So if Commissioner Novak and Commissioner West want to have a email conversation about the hottest new macaroni and cheese recipe, not city business, not discoverable, have it on your personal email. But if you want to have a discussion about the city having a bake sale to raise money for the planning department and about how Laura Turway is a terrible baker, city business, do it on the city email so that if in the event it has to be discoverable, it can. It wouldn't be Laura that's a terrible baker, it would be me that's a terrible baker. But the point is that it's city business, and it doesn't matter if the thing you're talking about is an application before you or not. If it's city business, it's discoverable. So you want to keep that in mind. You are responsible for maintaining these emails, and that's why another reason why we want you to use the city email address, so that the city can be responsible for complying with the public record retention requirements. And The other thing I want to tell you about public records and about emails is that email traffic between a quorum of decision makers can be a public meeting. So there are public meeting requirements when we get a quorum of you together talking about city business. That is a public meeting and it needs to be on the record and it needs to have notice. If Laura emails the staff report on an application to the HRB members and Commissioner Edgar has concerns about something in that application and he replies all, he is essentially starting a public meeting that is not a noticed and recorded public meeting. And so we want to avoid that reply all function when engaging with city business, unless we're talking about the next greatest macaroni and cheese recipe, because we want to, if you have questions about an application, respond just to city staff. So we're not creating a multi-party dialogue about city business outside of the public hearing process. So I had identified some recommendations for effective participation, but I think we've talked about participation, being attentive, being prepared, being open, being equitable, providing a forum where folks feel comfortable voicing their concerns, and making a decision based on the application materials and the public hearing materials submitted during the review. 701, Laura, sorry.
No, thank you very much. And I just want to tag on to the tail end of that staff's job is here to support you, to give you the information that you need to make an informed decision. So please use us. If we're doing something and you have suggestions, please let us know because our job is to serve you. And then the other thing is, though you have done an hour of legal training, we have not checked the box for the year. We're going to continue conversations since we're at the end of this meeting. Please email, if you're on the Planning Commission, you can email me any questions and we'll follow up at more hearings with more talk about this. If you're on Historic Review Board, please email Kelly and she can continue the conversation there too. So much more to come.
Okay. At this point, we do have a Planning Commission meeting. Planning Commissioners, reminder that you have to log off of this meeting and log into the new meeting. It's 7:02 right now. We'll try to start the Planning Commission meeting at 7:05. So this session is adjourned.